The verse of the Quran that governs the issue of residence of wives, existing and divorced, says, "Make the women reside in the same style as you reside. Annoy them not, so as to restrict them. And if they are pregnant, then spend your substance on them until they deliver their burden." This verse applies to women undergoing their waiting periods after divorce, in the case of those who are not pregnant and those who are. The verse is telling us that even though you have divorced women, you have to treat them as your equals in terms of residential facilities and treatment till such time their periods are over or they have delivered. When such treatment is to be given to women who have been divorced, then those who are still married are to be treated even better. The issue may be understood through the rules framed by the Hidayah. The first rule states that it is the liability of the husband to make his wife reside in an independent house in which there is no one else who belongs to his family, unless she chooses that herself. The reason is that residence is part of what is deemed adequate for her. Therefore, it is obligatory like maintenance. Accordingly, Allah has made it obligatory along with maintenance. If the Almighty has made it obligatory as her right, then the husband has no right to make her share it with another. The reason is that such sharing is injurious for her as she cannot be carefree about her things. It prevents her free interaction with her husband as well as from cohabitation. The exception is where the woman chooses this herself, for then she is agreeing to the reduction of her rights. The second rule says that if the husband has a child from another, then he does not have the right to make it reside with her. If, however, he makes her reside in a room within a house, where it can be closed, it would be sufficient as the purpose has been achieved. The third rule says that he has a right to prevent her parents, children from another man, and her relatives from visiting her in her house. The reason is that the residence is in his ownership and he has a right to prevent entry into his property. He is, however, not to prevent these relatives from seeing her or speaking to her at any time they choose, as that will amount to the severing of the womb. Some jurists say that he is not to prevent her from going out to visit her parents, nor to prevent them from visiting her each Friday. If the husband disappears and he has wealth that is in possession of another, who acknowledges it, the qazi is to award maintenance from this wealth for the wife of the missing husband, the minor children and his parents. The reason is that she has a right to take from the wealth of her husband without his consent. The same applies to wealth held by someone by way of mudarba. The same response is given in the case of a debt. All this applies if the wealth is of a type that can be claimed through her right, like dinars and dirhams, food or clothing that is suitable for her right. If, however, the wealth is of another species, maintenance is not to be awarded, as for that he will need to sell the goods, and the wealth of the missing person cannot be sold by agreement. The person who holds the wealth of the missing person is to take a surety from her for the amount paid, in the interest of the person absent, because it is possible that she has already taken the maintenance or her husband has divorced her and her waiting period is over. She is also required to take the oath by Allah for what she is paid to preserve the interest of the missing person. There are different views in the Hanafi school when it is not known that the woman is the missing person's wife, but she brings witnesses to prove this. Or in the case where the missing person has no known wealth and the woman brings witnesses to prove that she is his wife and that she should be allowed to raise a loan against the liability of the missing person. In such cases, one view is that the qazi is not to adjudicate such cases as he would be doing so against a missing person. Another view is that he may adjudicate the cases as it is for the preservation of the wife's interest, while there is no injury in this to the interest of the missing person. If he were to reappear and affirm what she has claimed, she will have taken her right. If he denies it, he will be made to take the oath, and if he refuses, he will be affirming her claim. If she were to bring witnesses, her right would be established. But if she is unable to establish it, the surety or the woman will be held liable. The later qazis acted upon the second view. If a man divorces his wife, then she has maintenance and residence during her waiting period, whether the divorce is revocable or irrevocable. Al-Shafi said that there is no maintenance for the woman separated irrevocably, unless she is pregnant. The Hanafis argue that maintenance is in lieu of confinement to the house, and confinement subsists with respect to the main purpose of nikah, which is procreation. As the waiting period is obligatory for the preservation of progeny, it leads to the obligation of maintenance due to which she has residence too on the basis of consensus. It is as if she has become pregnant. There is no maintenance for the woman whose husband has died. The reason is that her confinement is not due to the right of the husband, rather it is due to the right of the law. And her staying confined is worship on her part. Do you not see that identification of the vacation of the womb is not taken into account in this, so that taking note of menstruation is not stipulated in her case? Accordingly, maintenance is not made obligatory for her. Further, maintenance becomes due in phases, and he has no ownership after death. Thus, it cannot be imposed on the ownership of the heirs.